May it please the court, Justice Kolapen and Justice Majid, S.O. Khosa from State Attorney Pretoria, I appear for the third respondent.
May it please the court, Justice Majid, Justice Kolapen, I am Phumzile Sokela, appearing for the fifth respondent on instructions from Chidil Thompson and Haysom attorneys.
Today, the Constitutional Court hands down judgment in an application for confirmation of the Order of Constitution invalidity granted by the High Court of South Africa. The application was brought by three applicants: Arena Holdings, a private company that owns various media houses; Amabungani Center for Investigative Journalism, a non-profit company engaged in public interest investigative journalism; and Mr. Warren Thompson, a financial journalist who was employed by Arena at the time of the High Court application. The respondents include the South African Revenue Service, SARS, the former President of the Republic of South Africa, Mr. Jacob Zuma, the Minister of Justice and Correctional Services, and the Minister of Finance. The Information Regulator, as the authority tasked with monitoring the enforcement of the Promotion of Access to Information Act, PAIA, was also a respondent. The matter concerns the constitutionality of sections 67 and 69 of the Tax Administration Act, the TAA, and sections 35 and 46 of PAIA. The High Court declared sections 35 and 46 of PAIA unconstitutional and invalid to the extent that they preclude access to tax records by a person other than a taxpayer, a requester, even in circumstances where the requirements set out in subsections 46A and B of PAIA are met. Early in 2019, Mr. Thompson made an application to SARS in terms of PAIA to gain access to Mr. Zuma's tax records. The application was premised on allegations made by Mr. Jacques in his book titled The President's Keeper and several other persons. It was averred that there was credible evidence, in inverted commas, that while he was president, Mr. Zuma was not tax compliant. SARS refused Mr. Thompson's application on the basis that Mr. Zuma was entitled to confidentiality under sections 34 subsection 1 and 35 subsection 1 of PAIA, as well as section 69 subsection 1 of the TAA. Mr. Thompson launched an internal appeal against SARS' refusal. SARS dismissed the appeal on the same grounds. The applicants then launched a constitutional challenge in the High Court, requesting it to determine whether tax information held by the state receives absolute protection from disclosure under PAIA. In their application, the applicants challenged the constitutional validity of the statutory provision of the disclosure of a taxpayer's information held by SARS, in circumstances where such disclosure would reveal evidence of a substantial contravention of the law and would be in the public interest. The High Court found in their favor and held that the notion preferred by SARS and the ministers that voluntary disclosure and taxpayer compliance is inextricably linked to or dependent on taxpayer secrecy is not a universal truth. The High Court also found that the assertion of the right to privacy and secrecy relied on by SARS and the ministers did not meet the limitation test in section 36 of the Constitution. The High Court found that the argument that public interest overrides the limitation of taxpayer confidentiality was justified, and that the impugned provisions unjustifiably limit the right of access to information provided for in section 32 of the Constitution. The High Court then declared the impugned provisions invalid and unconstitutional and read in on an interim basis the public interest override provisions contained in section 46 of PAIA. It also granted the application for the release of Mr. Zuma's tax records. The applicants accordingly approached this court to confirm the declaration of invalidity made by the High Court. In this court, the applicants submitted that there is an absolute prohibition on disclosure of tax information of a taxpayer held by SARS to a PAIA requester other than the taxpayer concerned. They also contended that these provisions prevent the media from obtaining or reporting on tax information, even if the information contains conclusive evidence of corruption, malfeasance, or other law breaking. The applicants argued that the impugned provisions are unconstitutional to the extent that they unjustifiably limit the right of access to information under section 32, subsection 1 of the Constitution. They also submitted that the right to freedom of expression under Section 16 of the Constitution is implicated in that the media is prevented from lawfully obtaining tax information and from reporting on it. They say that the limitation of the rights in Section 16 and Section 32 of the Constitution is not justifiable and that the impugned provisions are not necessary to protect taxpayer privacy and compliance. SARS, on the other hand, submitted that the regime created by the Tax Administration Act and PAIA strikes a fair and reasonable balance between the right to privacy and the right of access to information. According to SARS, taxpayers are not only encouraged but are compelled to make full and frank disclosure of their personal information and secrets to SARS, including disclosure of their own criminal conduct. Taxpayers are essentially stripped of their privilege against self-incrimination. SARS submitted that the impugned provisions serve to preserve taxpayers' secrets and that the extension of the override provision in Section 46 will materially undermine both the assurance given to taxpayers that SARS will keep their secrets and taxpayer confidence in SARS. It argued that the impugned provisions of the Tax Administration Act were not absolute, as they were subject to narrowly circumscribed and tightly controlled exceptions. SARS contended that the relief sought by the applicants violated the right to privacy under Section 14 of the Constitution. Mr. Zuma sought leave to appeal against the orders that SARS should disclose his tax records to the applicant. He submitted that the applicants largely relied on the allegations of non-compliance made in the book The President's Keepers. According to Mr. Zuma, the book did not disclose any facts that would demonstrate credible evidence that he violated his tax obligations, in that there are no allegations of specific amounts paid to him that were not subject to tax. The allegations that he was not tax compliant emanated from unnamed and undisclosed sources. The amount of tax alleged to be owed by him is not specified, and the author of the book has not been called to testify about the allegations. Mr. Zuma submitted that the relief sought by the applicants infringed on his rights to privacy and dignity. The Minister of Justice, while accepting that this matter implicates the right of access to information, said that this right was not absolute and was subject to the limitations. The Minister submitted that maintaining the confidentiality of taxpayer information was in the public interest and contended that the proposed extended public interest override was both speculative and discriminatory, as between ordinary non-compliant citizens and prominent figures. Consequently, the Minister of Justice sought a dismissal of the confirmation application. Like SARS, the Minister of Finance also submitted that the confidentiality regime created by the improved provisions of the Tax Administration Act struck a fair balance between the rights of a taxpayer to privacy, SARS' duty to effectively collect taxes, and South Africa's international obligations on the one hand, and the public's right of access to information on the other. The Minister submitted the High Court failed to take cognizance of public policy considerations, in that the confidentiality of information is critical for effective tax administration and the subsistence of the voluntary compliance policy. The Minister of Finance argued that the proposed public interest override was too broad and that the applicants and any other party could decide on a whim whose tax records they seek and cloak their request for those tax records under the vague umbrella of public interest. The Minister further advanced an argument that once the tax information has been released, SARS would not have any control over what is done with it. The regulator had filed a notice to abide by the proceedings. It said that any prohibition on the disclosure of a record that was not reasonable and justifiable limitation, as well as without grounds for refusal, was materially consistent with the objects of PAIA. The regulator contended that Section 35 of PAIA provided SARS with the absolute right of refusal of access to records they held, which is contrary to the factors under which the right of access to information can be limited. The first judgment, penned by my colleague Mtlantla J, and in which Matlanga J, Mbata J, and Chiki J concurred, disagreed with the second judgment on the question of whether the order granted by the High Court, which declared Section 35 and 46 of PAIA unconstitutional to the extent that they preclude access to tax records by a person other than a taxpayer should be confirmed. That judgment would not have confirmed the order of constitutional invalidity. It reasoned that in balancing the right to access to information and the right to privacy, the limitation on access and disclosure of tax information by anyone other than the taxpayer concerned was justifiable. Further, that the current framework of the Tax Administration Act already provided measures that may be resorted to for the purposes of striking a balance between access to taxpayer information and maintaining taxpayer secrecy. Moreover, this judgment held that if the ambit of the public interest override was to be extended, it would not only be applicable to public figures, but also to citizens and ordinary taxpayers whose tax records could potentially prove a substantial contravention of or a failure to comply with the law or an imminent and serious public safety or an environmental risk, and where their disclosure would potentially be in the public interest. This, said the judgment, would pose a challenge to the privacy interests of those individuals, and the confirmation order would be detrimental to the reputations and societal standings of taxpayers. Finally, on the substitution order, the judgment holds that the High Court prematurely granted the order requiring SARS to supply the applicants with Mr. Zuma's tax records, as no decision had been taken by SARS after the order of constitutional invalidity was made. The minority then would have set aside the substitution order with costs. The majority judgment, which I penned, and in which Bakwa AJ, Majid J, Matopo J, and Rogers J concurred, agreed firstly that this matter engages the jurisdiction of this court and that leave to appeal should be granted. It, however, disagreed with the conclusion that the prohibition on access to taxpayer records found in Section 35 of PAIA, read with Section 46 of PAIA, was not absolute. It concludes that the impugned provisions do not pass constitutional muster as they do not meet the limitation test in Section 36 of the Constitution. The majority judgment, emphasizes the importance of the rights to privacy, access to information, and freedom of expression, and holds that these rights achieve different but legitimate and interconnected individual and societal interests. It holds that the case is about the balance to be struck between these competing rights, specifically how that balance was managed between the right to privacy in respect of taxpayer records against the communal interest and the claimed right to access those records when they provide evidence of serious criminality or a risk to public health or safety. The majority draws on the framework referred to in the case of Bernstein, that as one moves away from the inner sanctum of one's life to the communal space that comes with living in society, the scope of that personal space shrinks. In those circumstances, the claim to individual autonomy and the right to privacy that attaches to it must be moderated against the public interest. The majority then holds that the effect of the public interest override was to continue to maintain a high level of confidentiality while providing a carefully crafted, limited, restrained, and relatively onerous basis for the lifting of confidentiality in the public interest. This court holds that Section 35(1) of PAIA protects all taxpayer information irrespective of whether its character warranted protection. Taxpayer information was totally immunized from the Section 46 override that applied to all other categories of information that enjoys protection in terms of Chapter 4 of PAIA. The court holds that PAIA and not the TAA is the national legislation contemplated in Section 32 of the Constitution to give effect to a general right of access to information. The majority went on to hold that although the Tax Administration Act provided for some exceptions to the general prohibition, such as providing information to a court in respect of proceedings related to the Tax Administration Act or the South African Police Service and the National Director of Prosecutions for the purpose of proving a tax offense, they all related to the work of state organs and courts in investigating, prosecuting, and adjudicating tax cases and related matters. Disclosure under sections 69 and 70 of the Tax Administration Act was not public disclosure which would be aligned with the public interest. The majority judgment found that all these exceptions were all exclusively TAA exceptions. They were standalone exceptions solely relevant to the operation of the TAA, and disclosure could only be made to the entities described therein. Given that the TA exceptions were totally disconnected from the operation of PAIA, there could be no basis to suggest that those exceptions had the effect of rendering the prohibition on disclosure found in Section 35(1) anything other than absolute. This court then concludes that arising from its judgments in Joncom and Chipu, and the conclusion that the prohibition in Section 35, subsection 1 is absolute, it must follow that the prohibition cannot withstand constitutional scrutiny. The purpose of the limitation as being necessary to achieve taxpayer compliance does not pass the limitation test. Some limitations may be justified, but no case had been advanced for an absolute limitation. This court accordingly finds that the limitation in Section 35(1) is absolute, cannot be said to be reasonable and justifiable in an open and democratic society. The Section 46 override provides a mechanism that is not only less restrictive than an absolute prohibition, but is also one that is narrowly constructed with substantial checks and balances. It holds that Section 35, subsection 1 and Section 46 of PAIA, as well as Sections 67, subsection 4 and 69, subsection 2 of the TAA are unconstitutional to the extent found by the High Court. In the result, the following order is made. 1. The order of constitutional invalidity of the High Court of Sections 35 and 46 of the Promotion of Access to Information Act No. 2 of 2000, PAIA, to the extent that they preclude access to tax records by a person other than a taxpayer, even in circumstances where the requirements set out in Section 46 of PAIA are met, is confirmed. 2. The order of constitutional invalidity of the High Court of Sections 67 and 69 of the Tax Administration Act to the extent that they A. preclude access to information be granted to a requester in respect of tax records in circumstances where the requirements set out in Section 46 of PAIA are met, and B. preclude a requester from further disseminating information obtained as a result of a PAIA request is confirmed. The declaration, number 3, the declarations of invalidity in paragraphs 1 and 2 above are suspended for a period of 24 months from the date of this order to enable Parliament to address the constitutional invalidity found to exist. 4, pending any measures Parliament might take to address the constitutional invalidity, the impugned provisions shall read as follows. A. Section 46 of PAIA shall read, quote, mandatory disclosure in the public interest. Despite any other provisions of this chapter, the information officer of a public body must grant a request for access to a record of a body contemplated in Section 34, subsection 1, 35, subsection 1, 36, subsection 1, 37, subsection 1A or B, 38A or B, 39, subsection 1A or B, 40, 41, subsection 1A or B, 42, subsection 1 or 3, 43, subsection 1 or 2, 44, subsection 1 or 2, or 45, if A, the disclosure of the record would reveal evidence of Roman 1, small Roman 1, a substantial contravention of or failure to comply with the law, or small Roman 2, an imminent and serious public safety or environmental risk, and B, the public interest in the disclosure of the record clearly outweighs the harm contemplated in the provision in question. B, subsection 69, subsection 2 of the TAA shall be read as if it contained an additional paragraph, open brackets, small b, capital A, close brackets, after the existing paragraph B, reading, where access has been granted for the disclosure of the information in terms of the Promotion of Access to Information Act 2 of 2000. C. Section 67, subsection 4 of the TAA shall be read as if the phrase, open quote, unless the information has been received in terms of the Promotion of Access to Information Act, number 2 of 2000, close quote, appeared immediately before the full stop. Paragraph 5, in the event that Parliament does not remedy the constitutional defects within 24 months of this order, paragraph 4 of this order shall continue to apply. 6, the applications for leave to appeal of the first to the fourth respondents are granted. 7, the appeals by the first respondent and the fourth respondent against paragraph 9 of the High Court order are dismissed. 8, the appeal by the third respondent against paragraphs 1, 3, and 4.1 of the High Court order is dismissed. 9, the appeal by the fourth respondent against paragraphs 2, 4.2, and 4.3 of the High Court order is dismissed. 10, the appeals by the first respondent and the second respondent against paragraphs 5 and 7 of the High Court order are upheld, and those paragraphs of the High Court order are set aside. 11, the appeal by the first respondent against paragraph 6 of the High Court order is upheld, and that paragraph of the High Court order is set aside. 12, the request of the third applicant under PAIA for access to the individual tax returns of the second respondent for the 2010 to the 2018 tax years is referred to the first respondent for consideration afresh in the light of this order. 13, the third applicant is afforded 1 month from the date of this order to supplement his request for access to the records referred to in paragraph 12 of this order. 14, the cost of the applicants in this court in respect of the confirmation proceedings shall be paid by the first, third, and fourth respondents and shall include the cost of 2 counsels. And finally, paragraph 15, the parties shall bear their own costs in respect of the appeals by the first to the fourth respondent. The judgment is handed down.